The Nullification Trap. Every man who loves peace, every man who loves his country, every man who loves liberty ought to have it ever before his eyes, that he might cherish in his heart a due attachment to the Union of America and be able to set a due value on the means of preserving it. Now that's what James Madison said in Federalist Papers number 41 in 1788. Can a sovereign state refuse to yield to federal government law, executive order, or Supreme Court decision that a state deems unconstitutional or illegal, illegitimate, or otherwise? The answer is yes, absolutely, but not by state nullification laws. Nullification can be achieved in multiple other legal ways we need to focus on and educate all citizens to fully understand. Otherwise, it's a trap. As a former Tenther whose limited knowledge had me believing that the 10th Amendment was somehow superior to all the others and the Constitution, I was the problem. I discovered the proper legal process blessed by Chief Justice John Roberts in his 2012 opinion, instructing sovereign states in a new precedent to resist and not yield. His new written opinion clearly establishes new precedent and how states, quote, have the right and duty to simply refuse to yield, and that legal process defines interposition as the approved process to resist and not yield. Very different from nullification. Chief Justice Roberts' 2012 opinion of the Supreme Court of the United States sets new precedent, giving states the legal process for their, quote, right and duty to simply refuse to yield to illegal federal law. Now, wishful patriotic thinking deceives many state legislators regarding nullification, some claiming nullification has never been ruled on its merits by the Supreme Court of the United States. Well, now that's just dangerous error. Such deception and misinformation causes false security in illegal nullification acts that the Supreme Court of the United States has a long, consistent history of voiding. 10 southern states passed nullification laws opposing new anti-segregation laws. Supreme Court decisions demanded school integration, particularly Brown versus Board of Education. All 10 states are integrated today. Nullification is a state law nullifying a federal law or order. Now, a state thereby declares itself alone is the Supreme Court of our Supreme Court of the United States of America, superior to all the other 49 states and the contract terms that our state and those 49 states pledged on our state honor to accept and defend against all foes, foreign and domestic. Our U.S. Constitution is that contract. 50 states swore allegiance to it, not 49. Such a state acts with no legal, historical, or moral merit to that claim, which is why every state nullification law to date was voided and will always be voided. Nullification of a federal law by any one state is for some reason considered a state right by misguided 10th Amendment advocates as one way to interpose, but it's entirely unconstitutional. It's been ruled unconstitutional every time, consistently over 200 years. Yet every 20 or 30 years, a new generation reads the 10th Amendment in a vacuum, creating a new state sovereignty nullification law movement shaming their state forefathers who entered and swore an oath to defend the sacred contract that created the United States of America. Surely our own state legislators swear the same oath as our forefathers to protect and defend that same U.S. Constitution when elected. So, state nullification laws expose in that state alone issues of honor and character of a current generation that dishonors only their own state's prior generations, whose sworn oath is what is being nullified by the very posterity their forefathers sacrificed for all their liberty. United States requires every state, or we are in chaos. A house divided against itself, which we know cannot stand. One state cannot dictate to 49 others, which is what a single state does with a nullification law, which voids the will of 49 other states who continue to honor their state contract signed by their forefathers. Now, I regret that I may embarrass many friends, including state legislators that I know over 28 to 30 states that I personally counseled and have legislation pending with, and several governors. Many are sadly misguided. A few hubris overloaded lovers of nullification laws, which breach the contract every state agreed upon, the United States Constitution. Too many were misguided by establishment attorneys. None of those held Robert's embedded jewels that I'm speaking about. And secondhand, unverified misinformation. Sadly, apparently, since it was advocated by 10th Amendment centers in their state and the National 10th Amendment Center in California, again, Mark Twain says it best when he said, quote, "In religion and politics, people's beliefs and convictions are almost in every case gotten at second hand and without examination from authorities who have not themselves examined the questions at issue, but have taken them at second hand from other non-examiners whose opinions about them were not worth a brass farthing." And that's from the autobiography of Mark Twain. 10thamendmentcenter.com in California still operates today from the founder's home, who remains a full-time audiovisual salesman with a former sports writer and a friend, none having a degree or formal education in the Constitution, but all very skilled in the art of recruiting cash donations by riding waves of outrage at our federal government. Nullification is our right, the primary fuel for the 10thamendmentcenter.com and other 10ther groups in most states. It's now joined by their new cries from the same 10th Amendment centers to abandon U.S. currency and to use Bitcoin instead in order to drive the federal government to its knees. They have yet to set the example, however. Tragically, the same state legislators buying and reselling their nullification is our right arguments are influenced by people they have not vetted, but they quote them like they were James Madison or Thomas Jefferson. Every few decades, over 200 years now, state hubris selects one amendment, the 10th Amendment, to be superior over all the other amendments, to hold its breath and stomp its feet in righteous anger in declaring, "We're a sovereign state with 10th Amendment rights. So our state hereby recalls and assumes the rights we voluntarily delegated and surrendered in trust to our Supreme Court of the United States to decide what laws are legal." And our state decides we oppose this particular law, so we just void it by a state nullification law. States can just say no to any federal law we do not agree with and declare it void? United States created the federal government when every state signed a contract with terms and conditions binding on every state and their posterity. So can just one state breach this contract, our American Constitution, to unilaterally change that contract to gain control of the creation of the citizens of the 50 states? If that can happen, any one state could create chaos for the other 49 states at any time. Any one state can decide to occasionally assume authority over the Supreme Court of the United States. If so, any one state could undermine any court decision, usurping the authority invested by all 50 states in the Supreme Court of the United States. How would that not be tyranny to the other 49 states? Any one state would then become self-appointed, non-elected, super Supreme Court over the Supreme Court empowered by our Constitution. That one state contracted as our final authority, the Supreme Court, on the honor of the state now breaching their own contract. Now let's carry that misguided thinking to a logical conclusion. If a state can nullify federal laws, then a city can nullify state laws. And a neighborhood or a district can nullify city laws. Until we have anarchy by undermining and breaching contracts that we agreed on our state's sovereign honor to abide by when we signed up. How many cities, counties, communities in your state are sovereign? How many can overrule your state's Supreme Court when they dislike a law or a ruling? Various 10th Amendment centers operate on severe, raw emotions of frustrated patriots to push nullification rights. But the truth is very clear, contradicting and incontrovertible. Every state nullification law has been ruled illegal without exception because states voluntarily contracted those rights to our Supreme Court of the United States of America in trust. Many obvious unresolved authority issues resolved by the U.S. Civil War in 1861 to 1865. 10th Amendment rights are not superior or inferior to any other rights in our Bill of Rights, where the First, Second, 14th Amendments protect citizens just like our 10th Amendment. 10th Amendment nullification rights didn't fly when America finally got serious about all citizen rights and abolished racial segregation laws, denying equal rights and opportunities to blacks simply over their skin color. 10 southern states enacted nullification laws to preserve racial discrimination, and all 10 were rightly voided by the Supreme Court of the United States. So, 10th Amendment rights are not superior or inferior to other amendments, but all function in proper balance, the American way. Now, states voluntarily surrendered those nullification rights, quote, to the legislative, judicial, and executive branches, respectively, when states voluntarily formed the United States of America in a signed contract. State nullification laws are nothing more than a legal breach of contract. As the contract every state signed, the American Constitution, does not give any one state the authority to to declare void any law by duly elected Congress created by that contract. Every state contracted their authority to nullify federal laws via the U.S. Constitution to the Supreme Court, who has ruled many times consistently that one state can occasionally exercise authority to simply nullify by state law any federal law duly enacted by Congress, or opinion rendered by the Supreme Court of the United States, or legal executive order by the President of the United States or his assigns. So effectively, states did create federal government by contracting certain state rights permanently in order to empower the federal government. Nullification rights were given in trust to the legislative, judicial, and executive branches, which check and balance each other. Now, this was the will of we the people, confirmed by the Civil War. State nullification proponents may disagree by misinformation. They point to the Kentucky and Virginia resolutions of 1798 and 1799, in which Thomas Jefferson and James Madison asserted a state's right to nullify the Alien and Sedition Acts. Jefferson and Madison demanded the states have the final authority because the Constitution did not define an ultimate authority on such constitutional matters. Jefferson advocated nullification, while Madison advocated interposition, stating in the Virginia resolution of 1798, written by James Madison, which stated, quote, that this assembly doth explicitly and peremptorily declare that it views the powers of the federal government as resulting from the compact to which the states are parties, as limited by the plain sense and intention of the instrument constituting the compact, as no further valid than they are authorized by the grants enumerated in that compact, and that in case of a deliberate, palpable, and dangerous exercise of other powers not granted by the said compact, the states who are parties thereto have the right and are in duty bound to interpose for the arresting the progress of the evil and for maintaining within their respective limits the authorities, rights, and liberties appertaining to them, end quote. By this statement, James Madison asserted that the states are, quote, duty-bound to interpose to prevent the harm that would result from a, quote, deliberate, palpable, and dangerous unconstitutional action by the federal government. Madison did not specify the procedural legal details or process of how this interposition would be enacted or what result it would have. Now, Chief Justice Roberts affirmed Madison's interposition in his 2012 opinion. The Virginia General Assembly passed Madison's report of 1800. It acknowledged that states can declare federal laws unconstitutional, but the declaration would have no legal effect unless the courts agreed. Madison himself wrote, "State declarations are expressions of opinion, intended only for exciting reflection. The expositions of the judiciary, on the other hand, are carried into immediate effect." In 1803, via Marbury versus Madison, Chief Justice John Marshall defined that ultimate authority clearly. He wrote, quote, "It is emphatically the province and duty of the judicial department to say what the law is." Now, since then, instead of 50 individual state courts ruling regarding constitutionality, we have one Supreme Court. establishing one ruling for the entire nation. No state has, quote, unlimited sovereignty over any federal branch of government. In Federalist 78, Alexander Hamilton wrote, quote, limited constitution can be preserved in practice no other way than through the medium of courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. James Madison actually shared that view. He wrote, independent tribunals will be an impenetrable bulwark against every assumption of power in the legislative or executive branch. Since then, state nullification laws have failed every time by any state. Madison published notes on nullification in 1834. Madison was clear when he wrote that an individual state cannot unilaterally invalidate a federal law. That process requires collective action by the states. Nullification can be achieved legally, but only by the contract terms all states swore oaths to support and defend. When 2/3 of all states agree in unity, they can amend the contract and have done so 12 times since 1900 with 12 constitutional amendments. In 1842, the Supreme Court of the United States rejected Pennsylvania's attempt to nullify the Fugitive Slave Act of 1793 in the case Prigg versus Pennsylvania, number 41, U.S. 539 in 1842. That case was heard on the merits. In 1859, the Supreme Court rejected nullification in Abelman versus Booth. Booth had frustrated recapture of a slave in violation of the Fugitive Slave Act. Now, Wisconsin's Supreme Court held the act unconstitutional, but the U.S. Supreme Court reviewed on the merits and reinstated the conviction. In 1958, after 10 southern states refused to integrate their schools, as ordered by Brown versus Board of Education, 1954, the Supreme Court in Cooper versus Aaron held that, quote, nullification is not a constitutional doctrine. It is illegal defiance of the constitutional authority. State nullification law is a breach of contract with every one of the 49 states not joining in that nullification law. So it will always be illegal. Now, remember, 2/3 of all states agreeing in unity can legally change anything in our contract, our U.S. Constitution, that we choose to change, including nullification of any law. Examples are prohibition repeal, women's voting rights, popular election of senators rather than having our state legislators appoint senators to represent their state. And all these are forms from the terms of the contract every state agreed upon and signed on our honor. The Supreme Court of the United States explicitly rejected nullification in the case of Cooper versus Aaron in 1958. Arkansas had passed several laws in an effort to prevent the integration of its schools. The Supreme Court, in its only opinion to be signed by all 9 justices, held that state governments had no power to nullify the Brown decision. The Supreme Court held that the Brown decision and its implementation, quote, can neither be nullified openly and directly by state legislators or state executive or judicial officers, nor nullified indirectly by them through evasive schemes for segregation, whether attempted ingeniously or ingenuously. Therefore, Cooper versus Aaron directly held that states may not nullify federal law, a case certainly decided on its merits. If state and local governments could nullify federal law, public schools segregation would still be legal if nullification were legal. Virginia would have continued its ban on interracial marriages. Texas might still jail homosexuals for consensual sex under Texas former sodomy laws, and constructive gun bans would remain in effect in Chicago and elsewhere in violations of the First, Second, and 14th Amendments. Sovereign states can produce tyranny as well as our federal government. Both state and federal tyranny must be monitored with the proper checks and balances every state agreed on. Nullification law is actual secession from the Union by the breach of contract, the sacred contract that nullifying states swore their sacred oaths to support and defend over 200 years ago. Nullification is where 10th Amendment advocates unknowingly oppose our Constitution. Although with patriot intent and heart, I was one myself for many years as the problem and not the proof I advocate daily now. If a state deems a federal law or executive order to be unconstitutional, well, what's the proper process to resist? As we know now, it is not nullification. Because the Supreme Court is the ultimate authority, that remedy has always been before 2012. A federal court lawsuit challenging the constitutionality of this suspect federal regulation or statute. States were forced to play offense, bearing the burden of proof. That is now changed with my discovery of the Trojan horse cleverly embedded in the 2012 opinion of Chief Justice John Roberts in the Obamacare decision, as it's known.